Thank you. Please be seated. Well, looks like we have a couple of cases on our docket this morning. First one is styled Garcia versus the People. We've got that set for an hour-long argument. Both counsel look like you're ready to go. Counsel for petitioner, why don't you start?
Thank you. My name is Ned Jekyll. I represent the petitioner, Juvenal Garcia. My plan is to address the cert questions in order, beginning with the first cert question and my position that the law was settled at the time of trial and was settled such that the instructions deficiency was plain at the time of trial. Secondly, to any extent that the existence of a model instruction unsettled the law at trial, the deficiency of the instruction was made plain by the time of appeal by the amendment to the model instruction, and this court should hold that that is sufficient to make the error plain by following the U.S. Supreme Court case in Henderson. And then thirdly, to address that consolidating, when the legislature consolidated the first and second degree sexual assault crimes into a single statute, that it did not create any substantive change to what's required for criminal liability. So turning to the first cert question, that the error was plain at trial, both statute and well-established legal principle show that absent a clear intent otherwise, that when a statutory crime has a culpable mental state, that mental state applies to all of its conduct components, to each act, each of its defining acts. So for those crimes, criminal liability requires proof that the culpable mental state coincided with each of the acts. It follows then that a jury instruction must clearly convey that the culpable mental state applies to and modifies each of the defining acts of the crime. So how do you go about doing that? Well, you do that by formatting the instruction so as to offset and segregate the culpable mental state from the conduct elements of the crime. That's not my idea. That is the idea of Colorado appellate courts. That is what Colorado appellate courts have held in, among other cases, Bossert, Rodriguez, Chase, and Dunlap. So when is it that an instruction might be deficient? When does an instruction fail to modify the culpable mental state? It fails to do so when the instruction is formatted in such a way that it incorporates the mental state into one of the conduct elements. When an instruction is formatted in that way, it fails to modify the other conduct elements that follow. Again, this isn't my idea. This is what Colorado appellate courts have said in several cases, including Alman, Suazo, and Bornman, and Mascarenas, more or less. So,
Mr. Jekyll, can I jump in there? Good morning.
Sure.
Was there argument made by the prosecution that the knowingly didn't apply to the fourth element?
Was there argument made by the prosecution?
Right.
I don't believe so, no.
Okay, so it just would be in the formatting, not in necessarily the application.
Well, it would be in the application based on the testimony of the defendant, based on the conflicting testimony. It was in issue in the case, if that's the question.
I'm just
I don't know
wondering
that an argument was made one way or the other. I think the argument made by the prosecution was just that that CG's testimony was credible and the way it happened, and Mr. Garcia's testimony was not.
Okay, so I mean, I'm just trying to define if sort of the difference between the two elements was kind of a point of argument, or it was just sort of a global, you know what I mean? It's like,
Sure.
If the prosecution said, you know, he doesn't have to knowingly cause submission, that to me that's a much more glaring than if that's not necessarily argued.
No, I think the prosecution's argument was that his version of events was not what happened, that it was CG's version of events. But his version of events certainly puts this in play. I mean, it is a disputed issue at trial based on Mr. Garcia's testimony. He testified at trial.
Right. Okay, thank you.
So just going back to the propositions I stated, this statutory command or the statute regarding the applicability of a culpable mental state and the well-settled legal principle behind it, as well as the case law instructing on how to format an instruction so that it is conveyed to the jury that that mental state applies to each of its elements, and also the case law instructing that when you incorporate it into a single conduct element that does not convey that idea to the jury, all of that case law, all of that law existed at the time that this case was tried.
Mr. Jekyll, while you paused, good morning. So let's assume for a minute we agree with you that the error was obvious at the time of trial. Could you address why the error would reasonably undermine our confidence in the outcome? And I guess I'm asking you to respond to Mr. Kosaliski's argument. The element that deals with act or cause of submission by means of sufficient consequence, reasonably calculated to cause submission against the victim's will. I recognize that that's an actus reus, but it's hard to envision how you would unknowingly, reasonably calculate to cause submission against somebody's will. So help me understand, if we agree with obviousness on plain error, why this undermines confidence in the verdict here.
Sure. Well, first I would redirect you just a little bit.
Sure.
Miller describes that prong of plain error when it comes to instructions as an error that affects a substantial right, and that it's reasonably possible that it contributed to the verdict. So keeping that in mind, and in this case, are you asking me why the instructions as a whole did not get that across to the jury?
Yeah, tell me why that prong of why you kind of meet that prong of plain error here, or don't.
Okay,
Sorry.
sure, yeah. Well, in this case, the testimony is conflicting, but what is not conflicting is that some sort of physical struggle, tussle, whatever you want to call it, preceded the sexual contact. Now, according to CG, it was basically Garcia trying to disrobe his wife and have sex with her. According to Mr. Garcia, the physical tussle was initiated by her. She was upset about his effect on her relationship with a boyfriend and so on and so forth, but at some point it transitioned into consensual sexual contact. So what is required, given his testimony, is that the jury understood there was some physicality involved, some means, and in order for him to be criminally liable for that, he has to be aware of the nature of his conduct and the circumstances that his conduct is causing this sexual contact that ensued after the initial physical struggle to have caused submission rather than to have caused or resulted in consensual conduct. So that's where I would say that the prejudice in that particular prong is met in this case. It's based on the conflicting testimony, his version of events, her version of events. The jury, of course...
I'm sorry, go ahead. I forget.
The jury, of course, can accept parts of her version of events, parts of his version of events, piece them together. It could have concluded, that he may be unaware that whatever this physicality that preceded the sexual contact was causing submission or caused her to submit against will, or so on and so forth.
Sure, but when the jury found that, this caused submission by means of sufficient consequence reasonably calculated to cause submission against will, doesn't the jury necessarily reject that it was unknowing?
Not if they're not instructed that knowing applies to it.
So how could you have a unknowing action reasonably calculated to cause submission against someone's will? And forgive me if I'm just being naive.
No, I don't think so. I think the jury could find that the magnitude of the physical contact was something that would objectively cause someone to submit against their will. I think I mentioned in the briefs, and gosh, I think I talked in the briefs about, that sexual acts involve a certain degree of physicality sometimes, some people, and so on and so forth. So that's what we're talking about here.
Okay, thank you.
guess I'm still struggling with that. So the word calculate suggests a mental state that's arguably even higher than knowingly. I'm still not tracking why that wouldn't account for the mens rea, whether there wasn't essentially an implicit finding of mens rea here. So I guess I'm not satisfied by your answer to Justice Gabriel's question. Try again, please.
So why the reasonably calculated does not, when we're talking about here is what, does that convey a mental state to the jury or not?
Right, in evaluating whether ultimately the substantial rights were violated, et cetera.
So you accept my proposition that the instruction as formatted doesn't express knowingly to that particular element. But you
Well,
think
let's
within
say
that-
we do, but we're, right, which is what I gathered Justice Gabriel was trying to do as well. So we accept that, yeah.
Well, I guess I can by way of, the issue being why doesn't that convey the idea of a mental state to the jury, or why doesn't that convey any mental state to the jury? First, to double use the term objectively, it is an objective element of the crime. But you might analogize it to, say, the public indecency statute, for example. The court, that has an element, if I can remember what it is, and I know I didn't talk about it in the brief, so I apologize to counsel, that it's a crime to have sex where the conduct may reasonably be expected to be viewed by the public, okay? So the Court of Appeals rejected the argument that that implies any kind of mental state, and it held that that's a strict liability crime, because it says all that expresses the General Assembly's intent that that crime, that is just an objective standard. It defines the conduct, it describes the conduct that's involved. You may not know that this act was taking place in a place that you would reasonably, that the public would reasonably perceive it to be taking, in public view. However, you are nevertheless guilty of the crime because it is an objective standard. It defines conduct.
So,
Same with this clause.
but there's, and I realize both provisions use the word reasonably, so that does suggest some kind of an objective standard, but calculated feels like it has an element of intent, reasonably calculated to cause submission against a person's will. How does that not convey that there has to have been some calculation, some thought about whether this will cause submission?
That's where I'm getting hung up too.
Yeah, well, I'm not going to fight you, and I agree that that's one possible interpretation of it. It's not the interpretation that the General Assembly intended. Smith says that. Smith says that it is an objective standard, right? And so the question is that adequate to convey it to the jury when it doesn't even, it doesn't mention the mental state. It describes conduct. It's a passive voice sentence, and there's no subject to that sentence. The subject is not the defendant. It just says by means reasonably calculated. It doesn't say who's doing the calculation. So it suggests, I think, the better read, or the only read even, well, not the only read, but the better read is that it's an objective standard and it describes conduct.
But let me push back a little on you. You said it doesn't say who does the reasonably calculating. Provision A starts with the actor causes submission, but and then goes on. Doesn't A specifically refer to the actor doing the reasonably calculating? Yeah, of course.
Right. So it says the actor causes submission by any means, et cetera, et cetera. Oh, I'm sorry, I'm looking at the old
No,
secondary
but you're right.
section.
That's actor causes submission by means of sufficient consequence, reasonably calculated, et cetera. So it just says the actor causes the submission, I guess, by means that a objectively reasonable person would calculate. It's hard to read it that way.
Well, it's just. First it's referring back to the conduct, right? It's setting the bar of the conduct, so it's modifying conduct.
Yes.
And I don't think that the refer back is at all clear. And I think the fact that we're having this debate sort of shows the deficiency of the jury instruction and why it's imperative to format the instruction in a way that knowingly is set apart and clearly applies to the act. And again, I go back to the public indecency statute. There, smart people, the Court of Appeals said this is an objective standard. This doesn't attach a mental state. It's a strict liability crime. So,
Can I back you up? You used a phrase, since we're reasonably debating. Since we're having that reasonable debate, then does that beg the question of whether this error is plain? I mean, clearly the later instruction,
Right.
makes it so. But does that mean that at that time, I have to say that we can define plain error, but as a former trial judge, I think that it's to the point where the trial judge goes, whoa, wait a minute, this has got to stop. So.
No, I don't think that informs the plainness part of the plain error test. I think as far as its applicability or where it would factor into plain error, would be with the other prong, which is whether or not it affected substantial rights and, the outcome determinative thing. Was it a reasonable possibility that it contributed to the conviction? So I think that's where it comes into play. It doesn't come into play under plainness of the error. I think the error, the next part of my argument was it's a plain error because of those cases that I talked about, those cases instructing on how the jury instruction is properly formatted to convey to the jury that the mental state applies, how a jury instruction can be deficient in informing the jury of that. That is what this court, the Court of Appeals, has said makes for an error plain if it contravenes case law, and this instruction clearly contravenes case law.
To what extent should the model instructions inform plainness?
Well, this court has never said that the model instructions inform plainness. This court has said those three things. Does it contravene a statute? This does. The statute that instructs that the mental state must apply. Does it contravene a well-settled principle? Same thing, same well-settled legal principle. And does it contravene case law? And it does here as well. So the model instructions themselves caution that they're not to be followed when there is case law to the contrary.
Well, I understand all of that, but it still seems to me that we've essentially set up a regime in which there is a powerful incentive for trial judges to use the model instructions, and so
If you were to say that just slavishly following the model instruction makes any errors not plain, yes.
I probably would not say that. Okay. But it still seems to me to be a little disingenuous. We set up, we spent a lot of time crafting these instructions and essentially encouraging judges to use them, and then to turn around and say, well, it's not going to factor into whether or not any error was obvious seems, I don't know.
Well, I think maybe
inconsistent.
absent a statutory command, absent a well-settled legal principle, absent any case law, I think you could possibly at that point say that. If you're determining the plainness of an error at the time of trial, which maybe is an opportunity for me to segue into the second part of my argument.
At 12 minutes is probably a good idea.
Which is that to any extent, the error was not plain at trial. It's clearly plain at the time of appellate review, and it's clearly plain, I guess, because of the change in the model instruction, because the model instruction has changed. The committee got together, they said, no, we want to make sure that we clearly convey to juries that mental states apply to all of its conduct elements. And we're going to do that, and we have to do that basically by following the dictates of the case law, which is we're going to segregate them and offset them.
But
Isn't
now we like the model.
Well, I was just going to say, isn't that somewhat inconsistent with
Right.
your
I was
earlier
just
statement about
to
the,
qualify, but I don't accept the premise of the Court of Appeals that the model instruction made the error not plain at appeal. But assuming arguendo that it factors in, we sure don't have it at the time of appeal, right, because of the change in the model instruction. So I'm just covering all the bases, getting to that particular model instruction. That's changed. It's all clear. If you had any problem with the plainness of the error at the time of trial, you certainly should have no problem with the plainness of the error at this time. So with regard to that, I'd ask this, I think this court should follow Henderson for the reasons stated in the brief.
Can I push back a little bit? The plainness of the error, shouldn't that be at the time that the error is committed? It just feels like you're looking at it in hindsight. If it's plain, depending on the nature of it, and I'm accepting what you're saying that it's plain at the time without waiving that.
Time of appellate review.
Why is it at appellate review? Because it feels like we want the trial court to get it right at the time that the error is committed. Why would we look at that through that lens?
Well, we would also look at it at the lens of the state of the law at the time of trial, right? If it's obvious at the time of trial, it's.
Right,
it
I
is
agree,
plain
that's what I'm
error.
saying, but.
Okay. Why, in other words, why should we adopt Henderson, or why should we adopt
Right.
Henderson? Besides the fact that every state Supreme Court that's considered it has adopted it, and besides the fact that the Supreme Court adopted it, it serves the purpose of Rule 52B. It serves the purpose by allowing an appellate court to correct an obvious injustice, an error, particularly in a case, particularly in a case where the law becomes settled during the time of appellate review. I think I talked about Lucero in the brief a bit. This is a case where the law was, I believe, unsettled at the time of sentencing, and while the case was on direct appeal, this court held in Roberts that Mr. Lucero's 3 thefts, that the legislature really only authorized 1 conviction, 1 sentence. Well, he had 3 convictions, he had 3 consecutive sentences. I mean, that's, and the Court of Appeals declined to vacate 2 of his convictions, declined to vacate 2 of his sentences, because it said, well, the judge could not have anticipated Roberts. I mean, that's an obvious and glaring injustice, right? Mr. Lucero would be serving a sentence and suffering convictions for crimes that the legislature never authorized. So I think it's the better view. I think it allows this correction of injustice. If I were a trial judge, I think I would be, frankly, find some comfort if I miss something in the hustle and bustle of trial, or if the law changes, that the appellate court's going to get it right, is going to do the just result for the litigants.
Should we also adopt the federal standard for plain error? You're asking us to adopt Henderson, right? Should we
Asking to
change?
follow Henderson in this instance, yes.
Right. Should we also switch and adopt the federal standard?
In other words, the 4th prong of Lano, I guess, is what you're asking me, Justice Sommer,
Right.
right? Okay. I don't think it's necessary. I don't think it's wise. I think my colleague in the next argument may cover this a bit, but I believe that several state courts that have adopted Henderson have not said that they need to then adopt the 4th prong of Lano. And frankly, we're talking about adopting it in this circumstance. We're talking about very few cases. I think the federal system is different. There's probably a greater volume. I don't know much about the federal system, but there may be reasons for the 4th prong and discretionary review. I don't think that they apply here. I mean, there's already plenty of incentive at the trial level for an attorney to object. You have a much easier time of it on appellate review than you do under the plain error standard, which is already pretty onerous. So I think adopting the 4th prong just gives, I think it results in fewer errors being corrected. It gives the court an out. I don't think it's necessary. I think it's fairly well encompassed. Our plain error standard now already has an outcome determinative prong to it, and I think that's sufficient to serve judicial economy. I don't think it's necessary to drop the 4th prong.
Does it follow from that at least you're not arguing then that we should adopt the Henderson approach because that's how the U.S. Supreme Court has structured plain error for federal purposes?
I think it should inform your view of plain error, right? And I don't think that you need to, or to use this word, but slavishly follow the Supreme Court case in that. Although
you
there
don't
are reasons, of course, that to have to follow, to have uniform procedures in state and federal courts.
I guess that's what I'm curious about. If that's the argument, then why doesn't it also follow that we should adopt their understanding of Rule 52B?
Well, in part because you don't have to, and because the consequences, I think, it creates a possibility for more injustice rather than more justice.
Did Henderson even turn on the fourth prong of Olano?
No, it did not.
Can I, since I just interrupted you with 5 minutes left, could you move on to the last point and talk about the mens rea piece on 4024? And let me just, since time is limited, cut right to the chase. You talk about how District Attorney Grant had testified when the bill was amended to say no change is intended. So, and you argue, look at the old case law, said there's a mens rea requirement. My concern with that argument is if you look at the statute changed dramatically. In the old version of the statute, what's now 4024 was an element. It was a substantive element where it was. It's now moved to a completely different section. So doesn't that, regardless of what Mr. Grant testified, and I have great respect for him, don't we have to look at the language of the statute, and doesn't that matter?
Well, I think you can look at the statute and come to the same result as I'm urging. I think the plain language of the statute is that the mens rea still attaches to the, if the means involve actual physical force causing submission. I mean, there's no dispute, my colleague and I, we do not dispute that the knowingly applies to means of sufficient consequence, right? And if it applies to means of sufficient consequence, and those means involve this physical force causing submission, then it necessarily applies to that. And I think that's the plain read of the statute, and I think that's why his reliance on Whitrain is misplaced. This is not like the drug statute.
Could I just ask on that real quick? So would that rationale then apply to be indicating that the mens rea should always apply to any sentencing factor or factor that would increase the level of culpability?
I haven't thought through that, but I think not necessarily. I mean, I think it's quite clear from the face of the statute that it does apply. I don't think there's anything about something being a sentencing factor that is just incompatible with a mens rea applying to it. I mean, it could, it did. You know, Apprendi was more or less a sentencing, called a sentence enhancer, and it had, you know, this mental state, racial animus or something like that attached to it. So I don't think there's anything incompatible like my opponent says, you know, categorically, you can't apply a mental state to a sentence enhancer. So I guess I'd like to reserve the remainder of my time if there are no further questions.
You may.
Good morning. May it please the court, William Kozlowski, registration number 37824 on behalf of the people. I'd like to start, as my opponent started yesterday. There are a lot of interesting questions in this case, and I don't think this court has to deal with any of them under the facts of this case. On the knowingly part, it's our position that reasonably calculated to cause submission against the victim's will clearly implies that the actor must be aware that his conduct is sufficient in character and degree to likely cause non-consensual submission. So while it's more precise to offset knowingly and put it before the element, that under the terms of this statute, it is nevertheless conveyed to the jury. And so there was no error to start with. If you don't agree with that, then my next argument is that it is certainly not obviously so that it does not convey that to the jury. I think Mr. Jekyll said that it's one possible interpretation. Well, if it's one possible interpretation, then it's not obvious. And relying on that, and it was not mentioned at all, there's a Court of Appeals case on appeal now, Comar, that agrees with my position, that it is clearly conveyed to the jury, and while it's more precise to do it, to offset knowingly, that it nevertheless does. So you have a case agreeing with me, And just as a practical matter, I think that it conveys it. So it's no error. It's not plain because it's debatable. It's not plain because there's a case right now saying that he's wrong.
Is
And-
Comar a published decision?
Yes.
Okay.
And was it on the books at the time of trial here?
Not at the time of trial, but his whole argument is that it should be the time of appeal. Well, as we stand here today, this is that's the law in Colorado. If this objection was made in a trial court today, a prosecutor could say this instruction is sufficient, and the court would be bound to follow that.
But your second argument here is really based on the obviousness at the time of trial, correct?
Right,
Okay.
but I think under plain error, at a minimum, it has to be obvious at the time of appeal. If it's not obvious at the time of appeal, then plain doesn't mean anything.
And what's the status of that case, that Court of Appeals case?
Comar, I mean, that was decided and mandated. I'm sure, maybe cert was asked. I'm sure cert was asked and denied. That was my argument at the Court of Appeals. My argument was Comar has already decided this, so it's not plain. And I don't know why the Court of Appeals went with the model instruction reasoning.
That's a 2015 case, right, Comar?
Right, it came out between trial and appeal. And finally, I think there's no plain error on the attempted sexual assault count for prejudice reasons. And Mr. Jekyll discussed, well, possibly this became consensual sexual conduct. Well, we know that the jury rejected that. In the unlawful sexual contact verdict, the elements of that offense were correct. The defendant in the state of Colorado knowingly subjected a person to sexual contact with knowledge that the person did not consent. They found him guilty of that. So we know that they found that he knew she did not consent when he did this. Secondly, we have the burglary verdict. Under those elements, he had to intend to commit sexual assault while he was there unlawfully. And Justice Gabriel, you asked, how can you know, I forget, it's tough to come up with, how can you
Unknowingly, reasonably
cause
calculate.
submission? Well, I don't think you can intend to cause unknowing submission. Let's put it this way, you cannot unlawfully enter or remain in a dwelling or a place and intend for unknowing, non-consensual sexual conduct to occur. That just can't happen. Third, the verdicts in this case were a wholesale rejection of his testimony. He testified he did not touch her. He testified he didn't rip her clothes off. He testified he didn't get on top of her and force her down. His testimony was that this was consensual. It was not some strange thing that happened and then all of a sudden something happened and he had caused her submission and he didn't know he had. There were diametrically opposed stories on this, and the jury totally rejected his testimony.
While you're pausing.
sure.
Assuming that we do tackle the three issues, despite your recommendation we don't.
Right.
Why should we be considering where the plain error needs to be considered, trial or appeal?
The merits of that?
Right, I mean,
I think so whether you should adopt Henderson. My first argument is you have already rejected Henderson. In Scott, you adopted the specific standard that the U.S. Supreme Court rejected in that case.
There was no discussion of Henderson and Scott, was there? I
No,
don't even
no,
believe, I don't believe it was raised.
We wouldn't be here if
Right.
if you mentioned Henderson. But after Henderson came out, you adopted the specific standard that they rejected. So I think we're in a position now where you have to come up with reasons why that is wrong. You are not considering it in the first instance.
When you say we adopted it, do you mean we didn't change what we had been doing?
I think that's the first articulation The Court of Appeals had been doing it for a long time. The so clear cut that a trial judge should be able to avoid it without the benefit of objection. I think that's the first articulation from this court of that standard. And I think Scott cites a Court of Appeals case, and if you trace it back far enough, the Court of Appeals was citing Terman, which is the federal case that the U.S. Supreme Court specifically rejected in Henderson.
What about, like, I hadn't really thought of it that way, what about like Miller, where we sort of make clear that the error not only has to rise to the level of likelihood of affecting the outcome, but it also has to be plain and obvious. Are you saying in that case we didn't make clear that it was plain at the time the judge was ruling? I mean, I take it what you're suggesting is in Scott, was it, that
Yes.
that's the first time the Supreme Court ever said by plain we mean it has to be obvious to the trial judge? when he's ruling?
I'm saying that's the first time that you stated it in terms like that. I think if you go back, let me put it this way. I think obviousness is something that has kind of worked its way through the courts, and sometimes it was addressed, sometimes it wasn't, and parties and the appellate courts weren't precise, and we're trying to get precise, and that was the first precise formulation of the test.
Can you square your argument with the settled case law that says we apply the substantive law in effect at the time of appeal? That the defendant has it right and the law changes as the time of appeal, we apply that. Why doesn't that apply to plain error review? I mean, Henderson relied in part on that.
I think to me that's a separate question. Does he get the benefit of a decision? So if he doesn't, then he just loses. If he does, then the plain error test. To me, the plain error test is a different test than whether the law applies.
Sure, but aren't they inconsistent? I mean, the law says you get the benefit of, let's take a hypothetical that the substantive law just changed. So at the time of appeal, it's completely different. The law is settled. The defendant is allowed gets to the benefit of the change in substantive law. Under your view, you would say, didn't make the objection, you lose.
Well, if on direct appeal, yes, but this court has a mechanism to deal with that situation under 35C1.
How would it be? Go ahead.
Under 35C1, that specifically provides that if there is a change in the law while your direct appeal is pending, you can file and it applies to your case, you can file a sort of early post-conviction motion, and if in the interest of justice you should get relief, then it can be granted right then.
Why is that an efficient way to handle things? Why not say, just raise it now? Why make somebody go through a post-conviction motion? And is there law that requires that? I mean, like I say, there seems to be settled case law that you apply the law in effect at the time of trial, and I don't think those cases say you got to go file a 35C1.
I don't think there's anything that requires it, but your concern is there a way to do this? And there is a way, and it would be my position that that is more efficient. Let's say Crawford. Crawford comes out and a defense attorney says, well, I didn't object to this because it obviously failed under the old test. It was under a firmly rooted hearsay objection. But I clearly win now under Crawford. Well, he can go into court the next day, file a 35C, say, Crawford applies to my case. I didn't object because I didn't know it existed. I win under it, and that relief can be granted within much sooner than a direct appeal gets done.
But you're not suggesting that he can't also raise that claim on direct appeal.
Sure, he has a choice. He can raise it on direct appeal or go that route. To me, that is the more beneficial route that has a standard interest of justice that is arguably more lenient.
You're describing the 35C1 route as more efficient, but you're also suggesting that the outcomes would be different because by not playing the plainness of the error or change in the law when it's on direct appeal, and yet you would under the 35C1. I guess I'm trying to understand the distinction.
the outcomes could be different, but I guess bringing it back to Henderson is, well, why would we treat these people differently? And my answer is, well, maybe you shouldn't, but this court has given a mechanism where that defendant can get relief.
Could Mr. Garcia make an argument about this instruction under 35C1?
No, because there isn't a new case that is applied to his case that says he wins. To the contrary, there's a case right now that says he loses.
Right.
To make more of my Henderson argument, Justice Gabriel, you asked about what did Henderson turn on? To me, Henderson in large part turned on Johnson, which was established precedent from the U.S. Supreme Court. This court is not burdened by Johnson. There was a textual argument that the state or the government made in that case, and Justice Breyer essentially said, well, that's inconsistent with our prior precedent, so that doesn't fly. Well, we would make the textual argument. But I think the big question presented by the Henderson issue is, and I think Justice Boatwright touched on this, where do you want to put the burden to get it right the first time? And it's not about someone intentionally foregoing an objection. It's more about people and the lawyers in this situation they will react even subconsciously to incentives. And if you put the burden on the people in the trial court, it is more likely that they will do the diligent work to make the novel legal arguments and bring them up in that forum and get it answered at that point. And my opponent says, well, Henderson furthers the purpose of Rule 52, and he said, essentially, his interpretation would give relief in more instances. Well, my position is we're talking about what is the purpose of the plainness requirement. The purpose of the plainness requirement is to encourage you to object. And the only way to do that, the best way to do that, is to require an objection, to incentivize the objection as best we can in the trial court.
But is there not an element of fairness and justice? I mean, Henderson says, plain error review is not a grading system for trial judges. Has broader purposes, including, goes on from there, the goal is the application of a new rule of law and appeal will meet the demands of fairness and judicial integrity. Is that not part of what Rule 52 is about?
Absolutely. I just think we have things on both sides, correcting errors and encouraging people to make objections. And when you're weighing those, the purpose to encourage objections to the greatest degree and to lessen arbitrariness in results, you should put it on the people in the trial court. I think this is a good example. There's a lot of talk about arbitrary results, and I think you can come up with arbitrary results no matter where you draw a line. That's the nature of drawing lines. But it seems a strange system that potentially the only person who doesn't get the benefit of a decision is the person who made the argument first and won it. Because in that situation, the Court of Appeals can say, yes, we agreed this was error, but it was unclear at trial, it was unclear now, and we're the first people to say it, so you lose. But then everyone else after that gets the benefit of his decision. That seems to be the most arbitrary outcome of all these examples. As to the fourth prong, Justice Moore's question, Justice Gabriel, I don't think Henderson hinged on the fourth prong, but it is mentioned as a limiting principle as to why we are comfortable giving the obviousness to the time of appeal. Justice Breyer says we have the third and fourth prongs to limit the application of the rule. So while I don't think it's essential, it was it was definitely considered in that decision.
So let me ask you this, a similar question to the one I asked opposing counsel. So our Rule 52B is identical in substantive, for all substantive purposes to the federal rule. Why shouldn't we adopt Henderson and adopt the federal standard?
Well, I think if you're going to adopt Henderson, you should explicitly adopt the fourth prong, absolutely. I still think the better rule, even with the fourth prong, I still think the better rule is to judge it by the time of trial for the reasons I've stated, that encourages people, it incentivizes people to do the hard work in the trial court to make novel legal arguments, because if they don't, they know there is a potential later on that an error won't be obvious because it wasn't at the time of trial.
Mr. Kozalewski, let me just ask about this fourth prong of the federal plain error test. Is that really before us here? Have we teed that up?
No, I don't think I even mentioned it in my brief.
Thank you.
I guess as to the second issue, the force aggravator, it's sort of, my argument is similar to the first, except I have the added thing of the Court of Appeals case in my favor was in effect at the time of trial. So the error, he fails under Henderson and any plain error test, because plain doesn't mean anything if it allows a defendant to argue to this court that a case should be overruled that was in effect at the time of trial and still stood at the time of appeal. If he's allowed to overcome that, then obvious doesn't mean anything.
Do you think that that case was rightly decided?
Yes, it's Santana Medrano, absolutely. And my main argument, I'd ask you just to adopt its reasoning, but to respond to your question, Justice Gabriel, I think the legislative history, I don't think you even get to legislative history, but if you do, he said, well, we're not substantively changing anything, and I've said this before to the brief. Well, when something was an element and you make it a sentence enhancer, that's a substantive change. I think he meant to say the words don't change, but it is a substantive change.
Can I ask you to respond to Mr. Jekyll's argument that if you read subsection 4, these are just specific kinds of means, and means are an element, therefore knowingly should apply?
Sure.
I think I paraphrased that
Yes,
right.
no, I understand what you're asking. I think, let me answer the question this way. I think as a matter of law, there is no mens rea requirement as to the aggravators. As a practical matter, in a trial for sexual assault or attempted sexual assault, if provided the elemental instruction adequately conveys the knowingly mens rea, you will necessarily prove that knowingly also applied. And this case is a good example. Assuming the instruction is good enough, you have proven that the defendant knowingly caused submission by means sufficient consequence, et cetera, and then the force aggravator says, and those means were force. And if the jury checks that, they have necessarily found that that knowingly occurred. And that brings me back to sort of my first argument and kind of what you were discussing with my opponent. In a case like this where you're dealing with force and a struggle and the defendant forcing the victim down and trying to have sex with her, there isn't a situation where a defendant can say, or a jury would find that there was force, but he didn't know it was force. And the argument there would usually be, I didn't know she didn't consent, not I didn't know it was force. But once again, here we know that he knew she didn't consent because the jury specifically found that. I don't have anything else of this court.
I know that your analysis doesn't really require us to answer this question, but I'm curious as to your thoughts about the extent to which, if any, the model jury instruction should affect plain error review.
Sure. I actually don't disagree with what Mr. Jekyll said. I think it's a factor that can be taken into account if the instruction tracks the language of the statute, and this court has essentially strongly encouraged trial courts to give this instruction, and there's no objection, I think that factors in. To the extent, I guess answer it head on, to the extent the Court of Appeals said an instruction cannot be plain because it was consistent with the model and jury instructions, I don't think that's right. And I never made that argument before the Court of Appeals.
Thank you.
Thank you for your time.
Thank you.
Just number these. I think I have 5 quick points. First, let me talk about Comar, besides the fact that I'm arguing that it's wrongly decided and that it's wrong rationale. Comar does not inform the plainness inquiry in front of this court. I think that is an unprecedented view of plain error analysis to be charitable. The existence of Comar, if you look at Henderson, for example, Henderson, they decided they would apply, because they had announced Tapia, that they would apply a time of appeal review. In Tapia was also a plain error. I mean, and of course there were lower court decisions that said, well, this sentencing practice is perfectly okay, right? So is the Supreme Court at that point, the US Supreme Court, supposed to just throw up his hand and say, well, we think the statute does not allow this sentence, but because a lower court has said this sentence is allowed, I guess the error is not obvious. So Comar, the existence of the Comar decision does not inform anything about the plainness analysis. That's my first point. The second point, when Mr. Kozlinski talks about the jury's verdict informing or necessarily rejecting the lack of a mens rea, well, that's not right, because take a look at at Aumann, and Aumann was the same problem as here. It was that a mental state did not apply to the predicate crime of the felony murder. Here we've got the same sort of situation. The burglary, the predicate crime is the sexual assault. So the defect in that instruction also calls into question that verdict as well. Henderson, of course, did not reject a time of trial analysis for plainness. That still exists. So there's nothing about this court's prior decision saying if it's plain at the time of trial, it's a plain error. That's fine. That's still a test. An error that's plain at the time of trial is still a plain error. Why do we need to apply the mens rea to the force requirement? Well, the Colorado Court of Appeals in several cases has defined force and the actual application of force very broadly, to such that someone's body weight during a sex act constitutes this aggravator. So we need to tell juries that a person needs to know that whatever force is involved in the particular sex act is actually causing submission. Thank you for your time.
Thank you. Appreciate the arguments of both counsel. The case will stand submitted, and the court will be in recess for 15 minutes. Thank you. Please be seated. Next case on our docket this morning is styled, looks like Howard Walker versus the People. We've set this for 1 hour. Council ready? Petitioner, when you're ready to go.
Good morning, Your Honors. May it please the Court. My name is Meredith Rose, attorney registration number 45304, and I represent Mr. Kyrie Howard Walker. What strikes me about both of the issues in this case is that they ultimately turn on protecting the fundamental fairness of the trial. The first issue asks this Court to decide at what point we assess the obviousness of an error for the purposes of plain error review. Must that error be obvious at the time of trial, or can it be obvious at the time of appeal? And the second question addresses the other side of the plain error coin, prejudice. How do appellate courts decide when the prejudice from multiple errors is so great that it requires reversal? Neither of the legal questions in this case is very complicated. For the first, the United States Supreme Court in Henderson has provided the answer. When the law changes from the time of the trial to the time of the appeal, it is enough that the error is obvious at the time of appellate review to qualify as plain error. And the answer to the second question is also clear because this Court has 60 years of Colorado precedent to rely on. Reversible cumulative error occurs when multiple formal irregularities in the aggregate deprive a defendant of his right to a fair trial. There are many good reasons for this Court to adopt the time of appeal rule from Henderson. To begin with, the time of appeal rule promotes the consistent application of what the law is instead of what the law was. And it avoids what Henderson described as the temporal ping pong that's involved in applying a time of trial rule, which is exactly what the Court of Appeals did in this case with this Court's decision in Venalonzo. The Court of Appeals used Venalonzo to identify the error and reason that under Venalonzo, the detective's testimony that the gun was real based on its barrel size was improper expert testimony. But then the Court of Appeals pushed Venalonzo away and said, we're not going to use this case to determine whether the error is obvious because it hadn't been announced until after Mr. Howard Walker's trial. Another good reason to adopt the time of appeal rule is that it really embodies the reason that we have plain error review in the first place, which is to allow appellate courts to correct particularly egregious errors. A time of trial rule can hamstring an appellate court's ability to do that, even in cases involving watershed decisions. And a third good reason for this Court to adopt a time of appeal rule is that it will bring this jurisdiction in line with the United States Supreme Court, all the federal courts, and every state court system to have squarely considered this issue in Henderson. Adopting a time of appeal rule is not a hard question. The most compelling argument on the other side is the state's contention that this Court has already rejected a time of appeal rule in favor of a strict application of a time of trial rule. But that is not the case. This Court has never squarely addressed what Olano described as that special case where the law changes. What was the law at the time of the trial is no longer the case on appeal. And in fact, there are cases from this Court where this Court has applied a time of appeal rule, although it hasn't necessarily said that. And one case that I would point you to is Wend. It's a case about prosecutorial misconduct. And in that case, the defendant raised a plain error challenge to the prosecutor's use of the word lie multiple times during her trial. And this Court noted that since after her trial, the two decisions had come out. So we had Kreider and we had Domingo Gomez, where this Court adopted a categorical approach prohibiting the use of the word lie. And this Court applied those two cases on purpose and reversed Ms. Wend's convictions on plain error review. So it wouldn't be the first time. And although the state contends that this Court has rejected Henderson, that's not the case because this Court has never even cited Henderson.
May I?
Oh,
sorry,
yes,
sorry
please.
to interrupt. Is there a reason to, or a way to distinguish the circumstances of this case where the law changed through a decision of this court from the case we heard last hour where there was no change in the law. There was an adjustment to the jury instructions, but the law remained the same.
I think that's a good question. I think oftentimes the law really changes by a degree, and it doesn't often do a 180-degree turn. And here I think we have something that really did fundamentally change the way that we look at expert testimony. Vinalonzo came out and really has been recognized by the Court of Appeals and this court as having changed the way that we evaluate whether an opinion is expert or lay. And since Vinalonzo came out, this court has reinforced that role also in Ramos and Kabugu more recently. And so today, which is the time of appeal still, under those three cases, it's really clear that this was an error. Does that answer your question?
Yes.
Ms. Rose, while you've paused, good morning. Can you address, let's assume we agree with you that you look at the time of appeal. Why would this have been obvious error? As you well know, the law on whether a police officer's testimony is lay or expert is all over the place. I mean, very, very factually dependent, and the cases go different ways. So given that, how does Vinalonzo make this obvious error?
Well, I would point out that the Court of Appeals here in this case applied Vinalonzo straightforward and came to the conclusion that it was error. So it seems that Vinalonzo does make this error obvious.
Sure, so we have error, but why is it obvious, given that the case law and police expert lay testimony is all over the place? Not on the law, but on the facts.
Sure. I don't think it's necessary for this court to grant cert in every issue of expert opinion when it has created this framework for looking at expert testimony. So we've got blood spatter, we've got the child forensic testimony, we have a number of cases where this framework has been applied, and that's really the question. It's not whether there's a case on point where we know that a testimony about a gun being real in a picture is expert or not. I think that's slicing too finely. Here we have a framework, and I think it's similar to cases like Reina Abarca in the double jeopardy context, where this court says, this is the rule now. Under this rule, it's going to make future issues of double jeopardy obvious. We apply plain error on double jeopardy review. Here we have Vinalonzo under this framework where we look to the basis of the person's opinion, whether that's something that a lay person would understand or whether it requires specialized knowledge. That makes the error obvious here. It doesn't have to be a case so directly on point that it's about a gun and the barrel size.
Thank you.
Can I ask a question about, let's just go back to the rationale for Henderson. I appreciate the tension that the Supreme Court saw there between the rule of obviousness, that is that a trial judge, this would be clear, and even without objection, the judge should have been able to see that error. And on the other hand, the question of giving the defendant the benefit of a change in law. But although we may talk about obviousness because that's the way we had phrased the question before, what does obviousness have to do with the way the Supreme Court ultimately wound up deciding Henderson? Did they not just come down on the side of, if something is now established, the defendant should get the benefit of it? Does it have anything to do with whether somebody should have recognized the error and therefore not let it occur?
I think the obviousness comes into play in front of whatever tribunal is hearing it. So you're right, it wasn't obvious to the trial judge in Henderson, just like the improper testimony here may not have been obviously improper in this trial. But the question of obvious really turns on, now I'm looking at it today, under this case, it's obvious, and the defendant should get the benefit of that.
And again, you say obvious, he should get the benefit because I take it what you're saying is because it's clearly established now. But it's not that the Court of Appeals or whatever appellate court is looking at it can do anything about it to prevent it at this point. Is that clear?
No, that's not the issue anymore. I think one way of looking at plain error is whether it was so obvious that the trial judge could have stopped it. But when the law changes, that's just not a practical way of doing it. And there is a basic principle that Henderson says dates back to Schooner Peggy, that appellate court should apply the law as it is, that promotes faith in the system and judicial integrity. And sometimes there's just no way to prevent that error from having happened.
Thank you. Let me ask one question, follow up with that. Given that choice on the part of the U.S. Supreme Court, in effect, to do away with the requirement that it had to be obvious to the trial judge so that he could have stopped it, does it make a difference in their determination to give precedence to the question of giving the defendant the benefit of a clear change? Does it make a difference that they have an additional consideration with regard to plain error, and that is, even deciding that it was clearly established, that would not resolve the question under federal construction of 52B, whereas it seemingly would under our construction.
Right. So the question is, how does the fourth prong of the federal plain error analysis inform the court's decision to
You've
adopt
seen
this
my
rule?
through my circuitous phrasing of the question.
I just wanted to be clear. Reading Henderson, it doesn't appear to me that the fourth prong really had much effect on their decision to adopt the time of appeal rule. It seemed like what they were really looking at was whether we should apply the law now versus the law at that time, what's fair and what's obvious, and not so much whether we have this discretion to reverse only when the error substantially affects the fairness, integrity, or public reputation of judicial proceedings. I don't think that's really what factored into their decision, and I'm not sure that it's important, because in my briefing, I've identified at least 6 other states that have adopted the time of trial rules explicitly from Henderson, and 3 of those don't have a federal or a discretionary prong. Those would be Minnesota, Michigan, and Nevada. So they look at plain error much like we do, especially Minnesota, which I talk about a lot in the opening brief. They ask whether there's an error that's substantial and undermined the fairness.
To adopt Mr. Jekyll's phraseology from the last argument, but you wouldn't suggest that we need to slavishly follow what these other courts are doing.
No, Your Honor. We don't have to follow them, and this court isn't bound by Henderson either, but typically when our rule is based on federal rule, as it is pretty closely here, we look to federal decisions, especially the United States Supreme Court, for guidance.
Maybe I could ask just one follow-up in this chain. And with regard to the third reason that you gave then for why we might want to adopt Henderson, that is to be in line with the United States Supreme Court and now presumably with many of these other courts, how does that square with us not following the United States Supreme Court's interpretation of the identical rule, 52B?
Well, there are at least 3 states that don't. And it's not, because the fourth prong really wasn't central to the decision whether to adopt a time of appeal rule, it's not necessary for this court necessarily to adopt the fourth prong either. That's not an issue that I think is squarely raised by this case. I would love the opportunity to brief it if this court wants to go there. But there's no reason not to have a time of appeal rule and still look at plain error like we usually do. It's obvious, it's substantial, and it undermines our confidence in the verdict.
Thank you.
Go ahead.
Just to follow up, I guess, on the Chief's, given that we do, maybe it's just another way to ask the same question, given that the text of the rule tracks the federal rule almost identically, and given that we often look to federal precedent for interpretation of our rules, why not then just adopt both Henderson and the fourth prong? And I'm reiterating a question raised by Justice Moore in the last argument.
I haven't thought enough about the federal fourth prong to have a good opinion about whether this court should adopt it or not. I think there are probably some very good reasons on both sides. I think that it's not the way that we have typically looked at plain error in this jurisdiction, and it's not necessary to go there. That's a question that I think is really for another case.
So maybe you could articulate those differences in how Colorado has approached plain error, just philosophically, or what its purpose is.
I think plain error, the purpose of it in both our system and the federal system is to give appellate courts a chance to fix things that are particularly egregious. And here, we've really adopted an outcome determinative approach, like my colleague mentioned. The question is, like, can we say that this error here is likely to have affected the verdict? Did it really affect the way that the jury came to its conclusion? The federal rule, the way that I understand it, the error must be obvious and it must be substantial. It undermines substantial rights. And then they have one more lens that they look at it through, and they decide whether they want to reverse based on whether that error substantially affected the integrity, the fairness, or the public reputation of judicial proceedings. And I have to admit that I don't really understand what that means. So it's a different way of looking at it, and I think that they use more discretion.
Probably
appreciate
don't
your
have to
candor.
feel too lonely in that.
So, good morning, Ms. Rose. So Justice Marquez asked the question that I was going to ask you, and she asked it with a better accent than I would have. But let me ask you a related question. It seems like we have this system that's different than the federal system, and we seem to be happy with the system we have, and we seem to be saying, now we want to stick with our system. But then the feds do something, tweak it. They Henderson gets decided, and we seem to like that and want to pick and choose. And I worry about just taking parts from that. Shouldn't we be concerned about, borrowing from a decision like Henderson when our system is different than the federal system?
I think that's a great point. Henderson, I believe, provides some guidance for some very good reasons to adopt the time of appeal rule. It's not binding on this court, and I'm not encouraging this court to adopt that rule because Henderson does it, only that their reasoning is much better than anything that I could probably come up with. But we, in this jurisdiction, we don't have a hard and fast rule, whether we look at the obviousness of an error at the time of trial or at the time of appeal. This court has done it both ways. The Court of Appeals has probably done it both ways. It doesn't come up very often, this special case where the law changes. So I really think this is this court's opportunity to wrestle with this question, use Henderson for guidance, but ultimately the question comes down to what protects the fundamental fairness of the trial proceeding. And I would say that that's a time of appeal rule because we now know that this is an error. It's obvious today, and all that does is get the defendant over the obviousness hump. It's usually the substantial hump that the defendant will lose on in the plain error review.
Ms. Rose, good morning. If you look at the rationale of Henderson, the principles they relied on to adopt their time of appeal rule, is there anything in those principles that is inconsistent with Colorado law?
Not to my knowledge, Your Honor. I think that it's actually quite consistent with the way that we've historically looked at plain error. And there is no conflict there that I can see.
Thank you.
Just to touch briefly on the substantial nature of this error here, because in order for this to rise to plain error, it must not just be obvious, but it must also be substantial. Here, the state charged Mr. Howard Walker with first-degree burglary and conspiracy to commit the same. And so they had to prove that this burglary was committed by the use or threatened use of a deadly weapon. And that's why the detective was asked by the prosecutor, can you tell whether this gun is real? Is that a real gun? Because if the jury had any doubt about whether that was a real gun, it would be hard for them to make that case and hard to prove first-degree burglary. And I just want to emphasize that the gun in this case was not used in the video. It was never loaded or unloaded or fired. It was never found in the course of the investigation. And so the only evidence in this case that a gun was used at all is this surveillance video. And the gun is only visible on that surveillance video for about 10 seconds in the very beginning. And so, as the Court of Appeals said, we strongly doubt that a witness lacking specialized knowledge can determine whether a gun depicted in a video was real or faked based on its barrel size. And that's why this was a substantial error here, because the detective's improper testimony gave the jury the ability just to check that element off without having to really wrestle with whether they thought that that was a real gun. The opinion testimony here is obvious error. it's substantial, and it's reversible plain error.
Can I push back a little bit on it? Good morning. I mean, his testimony was that airsoft guns have a red tip and a small barrel, and it's a large barrel. I mean, it's not quite as definitive as this is absolutely a real gun, I can tell. I mean, he's distinguishing it from an airsoft gun. I'm not sure that that's beyond the realm of an ordinary person's knowledge.
So
I mean, to the point
Sure.
that a judge would go, wait a minute, you can't, that's improper. I mean, again, when we're talking about being plain error, I think,
Certainly, and I would say it was obvious under the cases existing at that time, including Stewart and Barron, because it crossed the line into testimony that an ordinary citizen wouldn't know about in terms of the barrel size. Maybe ordinary citizens know that the red tip indicates a fake gun. That's something I learned in the course of this case. But it did cross that line there. And so I think that's why it's substantial.
okay.
If this court disagrees that the improper expert testimony constitutes reversible error, then that error will become one of the 8 errors that this court will have to assess in the cumulative error analysis in the second issue. Because not only did the detective here testify that the gun was real, he introduced a number of other errors into this trial. He was the advisory witness. He was the last one to testify before the jury heard the instructions and began to deliberate. So his testimony, that there was probable cause for a warrant, that Mr. Howard Walker was not truthful or forthcoming in his police interview, all of those errors really have an outside effect.
Ms. Russell, if I can ask you, since your time is relatively limited, it is obviously of concern there are 8 separate errors, and some of them are fairly severe, I think. But it seemed to me the only issue in this case was Mr. Howard Walker, the guy in the video, or not. I'm not seeing that any of these errors, either individually or cumulatively, really go to that issue. They were more disparate. Some of them were fleeting. So help me understand how we have cumulative error, how they affected that issue, the identity issue, particularly when we have some evidence that in his interview, Mr. Howard Walker says, well, what'll it get me if I tell you who the other guy is? That's pretty devastating evidence, I think. So help me understand how we have cumulative error here.
Sure. So just to push back a little bit, I wouldn't say this was the only contested issue or the only issue in the case, because at trial, defense counsel has to choose a horse and has to ride it. So the best defense that they came up with was this wasn't the guy in the video. But that doesn't mean they somehow waive competent evidence on every other element, like the gun, for example. But in terms of how these errors interrelate, which I think is what you're really asking, at least 4 of them did undermine the theory of defense of misidentification. And the first one was the testimony that there was probable cause, because the detective said, I took this to my supervisor. He thought there was probable cause. Obviously, I thought there was probable cause. Then I took it to a judge, and he said there was probable cause too. So that's an indication that at least 3 intelligent humans thought that this was the right guy. So it undermines the misidentification defense. So did his testimony as to why Mr. Howard Walker's girlfriend became emotional, that she recognized him in that photo. That was speculative. He didn't have any personal knowledge as to why she was emotional, but it undermined her later testimony at trial that she didn't recognize him. So that's misidentification too. His testimony that Mr. Howard Walker wasn't forthcoming or truthful in his police interview, the effect of that is to say, if this guy wasn't the right guy, why would he be lying during his police interview? And then finally, the prosecutorial misconduct. During closing, the prosecutor said, there's only one person in this room that could tell you where all of the stolen items are now, and he won't, which is saying, if this wasn't the right guy, he would stand up here and he would tell you, he would testify. So there are at least 4 of these 8 errors that do undermine the misidentification defense, to answer your question.
So, I'm sorry.
I was done.
I didn't really hear an answer, though, to how damning, if you will, the defendant's statement was. What do you do with that? Why isn't that arguably dispositive when we look at reversibility?
That statement is not a confession. That statement is at most an acknowledgement that he may have recognized the perpetrators in the video. I think it takes it much too far to say, as the state did at trial and the state did it in the briefing, that this was actually a confession. At this point in the interview, my understanding is that he was quite emotional. He knew he was going to be arrested, and he was looking for some way to cooperate.
But wouldn't a reasonable person infer that when he talks about identifying the other person, that he's implying that he's one of the two people? Why isn't that a fair inference?
I'm not entirely sure exactly what he said during that interview. That's the detective's testimony. And I don't think that necessarily means that he is the one who was holding the gun.
So, Ms. Rose, looking at the briefs, it seemed to me that there were two additional potential errors where the Court of Appeals didn't really say whether it was an error or not. It said something like, even if this testimony was in error, it didn't amount to plain error or something along those lines. And then there was another one that had to do with prosecutorial misconduct, where I think the Court of Appeals said, even if the prosecution crossed the line, do those enter into the cumulative error analysis? And while you're thinking about that, same thing with the instructions. The Court of Appeals said that there were 2 instructional errors, but there were actually 4, because I think that the same errors affected the conspiracy instructions.
That's true, Your Honor. I think that's a good question. I'm not sure what this court should do when the Court of Appeals decides not to decide whether something was really an error. Of course, I think that to the degree that there is prejudice from those errors or not errors, that it should be added to the cumulative error analysis. I really confine my briefing to the 8 errors that they identified, because I think it's really clear that those are errors, and the state didn't petition arguing that the Court of Appeals is wrong on any of those. But ultimately, if this court decides that there was prejudice from those errors, I think it can consider it as well. I'd like to save my remaining time if this court has no more questions at this point.
You may.
Thank you, and may it please the court. John Lee on behalf of the people, bar number 38141. When defining the contours and reach of a particular standard of review, this court has generally looked to what makes most sense in regards to what best balances a defendant's interests against and along with the very reasons why we have graduated ranges of standard of reviews to begin with. The 2 issues before this court should prove no different. So to piggyback from the last argument, there are a number of important potential questions in this case, and I'd like to argue them all and ask this court to hold. 1, that obviousness in plain error focuses on whether the error would have been obvious to the trial judge. And 2, for the purposes of cumulative error, it is not, as the Court of Appeals found, a reimagined harmlessness error test as identified in Carraway, but it remains what this court has said it was, and what I think the defense agrees with is an exceptional remedy that applies only when a reviewing court believes that the aggregate errors precluded a defendant from having received a fair trial. Although we do disagree how to get there and what the consequences are, we do, I think, agree on that Carraway is not the correct standard on the second issue.
So you agree with her that we should stick with the Oaks standard?
We agree that yes, I do not think that the Howard Walker standard is the correct test for analyzing cumulative errors.
Right, thank you. Good morning, by the way.
Good morning. So
Too late.
I'll begin where defense counsel did and start with the plain error argument and the stare decisis. Defense counsel said that was our best argument. I love all my arguments on that issue equally, but it was my first, and I do think it is the hardest for them to overcome, so I'll start there. We've cited a number of cases where, regardless of the words that this court used, in holding that an error was not obvious because it's not plain because it's not obvious to the trial judge, this court necessarily, in those cases, addressed the issue of whether or not we look at the error, whether it's the time of appeal or at the time of trial. In the reply brief, in arguing that this court is not bound by the higher burden of stare decisis, defense counsel cites Webster, a 1925 U.S. Supreme Court case. How the U.S. Supreme Court views its own precedent, of course, is not binding how this court views its precedent. But more fundamentally, even under the test in Webster, this court's prior cases should get the benefit of the presumption that stare decisis provides.
Given that we were not confronted with the question we're confronted with today in any of those other cases, even if you think it's your best argument, I would love it if you would talk about the merits of this question. Assume it's not decided.
Of course. So there's two different ways to look at this case. Or to read Henderson as well. So in our brief, we argue that Henderson sets forth a methodology for deciding for why in a federal or state court how plain error should be applied. They argue it's more of a 6-issue checklist where if these 6 factors are present in your jurisdiction as they were in the federal jurisdiction, then you should adopt that plain error standard. So under our argument, and I guess assuming if we get here, we're assuming that under the premise of that which was not specifically decided is still fair game. If you look at what the U.S. Supreme Court did in Henderson, they looked at the text, they found it ambiguous, and because it was ambiguous, they then looked to its prior precedent to see how it could square its rule, and then also what it thought led to the most fair results. This case, on the first point, I think having looked at the briefs at Henderson, I raised a different textual argument than what was addressed or even raised in Henderson. The textual argument that was rejected in Henderson was arguing that the back clause of plain error brought to the attention of trial court, that the passive voice showed that its focus was on the trial judge. Although I think that is somewhat persuasive, I think the better textual argument is our rule says plain error. What's the plain meaning of plain? As we cited in the brief, it means absolutely, entirely. An error is only entirely in error if it was an error both at the time of trial and on appeal. In addition, as this court knows, we try to give words in every word in a rule effect. If we take out the word, it was strictly supposed to be a time of trial rule or time of appeal rule, you could just delete the word plain. If the rule just said errors or defects can be corrected, even though not brought to the attention of the trial judge, absent a time of trial rule, there would really be no purpose for the word plain. That could have just been omitted.
Except that if it's obvious at the time of, it could mean an error that is plain to the Court of Appeals or to our court could be corrected, even if not brought to the attention of the trial judge.
Yeah, and I guess I did acknowledge that in the brief, but I think that'd be a very peculiar result given the plain meaning of the word plain. And also the fact you included, that seemed to be a very limited purpose for that word. So looking at the plain meaning and how it's actually written, and this wasn't rejected by Henderson, I think the text supports a time of trial rule.
So what do we do? And good morning, Mr. Lee. What do we do with the law that says we apply the law in effect at the time of the appeal, of direct appeal? And that was a factor Henderson looked at. It said we've got the two competing principles the chief referred to.
It was, and there's really no dispute that regardless of how this court decides this case, there's cases on both sides of the rule. Both in this state, every state, the federal system, courts have held going both ways. So then the question really is, what is the best approach? And in this case, the reason why a time of trial rule makes the most sense is because, again, it's consistent with the very reason why we have plain error in the first place. We want to encourage objections. We want to encourage trials to get right the first time.
But you're making an assumption there. And I read to your Mr. Kozaliski before the language in Henderson that says plain error is not a report card for trial judges. We care about justice and fairness. So why is it not a better rule to say let's get it right when we're on direct appeal, regardless of what happened at trial.
Because we're not only looking at justice within a case, but outside a case. And we have the hypothetical in the answer brief where we discuss if it's a time of appeal rule, in certain cases, people will not get the benefit just based on when their appeal is handled. So, as we all know, depending on the attorney that you have or the case that you get, not all appeals go through the same time. So we could have a situation where defendants who raised the same claim were convicted on the same day, but their appeals are processed at very different times, where under a time of appeal rule, one defendant would get the benefit of the rule, but the other defendant would
But wouldn't the
not.
other defendant have post-conviction relief then, under 35C1?
They would, but they also would under the time of trial rule. So I'm saying, so that I don't think that, as that would apply to either of the rules, I don't think that's a rational justification.
But the result would come out the same, wouldn't it? I mean, so the person who's here in time, the new rule is decided, now we're on direct appeal, we're going to apply that. The person whose appeal got decided 3 days before has the benefit of a 35C1 and is going to get the benefit of it. In the end of the day, both of these parties will get to the same place. I guess it's an efficiency, part of it is an efficiency issue for me. Why would an appellate court ignore law that changed when it's, you have the chance to apply it?
So I guess two responses. One is that you have efficiency on appeal and you have efficiency in trial. So, and I think those two are competing, and again, that's a judgment call of whether it's better to decide it at appeal or if we do, consistent with why we have plain error in the first place, want to encourage it at trial. On the other hand, the other principle, I think, behind why we have these differing standard of reviews is kind of to have both we want justice in truth, but also the appearance of justice. And I think a rule that turns on the fact of you're not getting relief because it wasn't obvious to your lawyer, it wasn't obvious to the trial judge, like that is a rule with substance. Like that, there are reasons and understandable reasons why a defendant in that case is not getting the benefit of a rule. Versus if it's strictly a time of appeal rule, it's just whenever an appellate court decided to have changed the rule or to have found a new rule. And that to me seems to be far more arbitrary than one that looks at time of trial, which again, there are concrete reasons why that defendant is not getting relief.
If I can ask one more question on this line, then I'll leave you alone. So say we have the situation where law gets settled, was unsettled at the time of trial, or say law was A at the time of trial and it's not A at the time of appeal. When would it, and again, we have this law that say apply the law at the time of appeal. When would that principle, the law at the time of appeal, ever apply? Because it would always be subject to the plain error rule and, I guess on your view, not get reviewed.
It would be the next case. So it's if a court were to find error, then they would then raise it in the next.
But isn't that, and I lied, I'm going to ask another question.
Of course.
Isn't that inconsistent with the principle that the court applies the law at the time of appeal? You would say, if you say it applies in the next case, it seems to me that's inconsistent.
So I guess it's not, if the court decides that the rule is we apply the law at the time of appeal, again, that's deciding the Henderson question. So I mean, I guess I really don't have a good response, because the issue, I guess to me in this case, is whether or not that rule invariably has to apply. And it's certainly our view that it hasn't, I mean, as evidenced by the fact that this court did not apply it 4 times in the last 3 years in Penn, Scott, Romero, and Smith. And also, I guess just returning very briefly to the fairness and equity question, it's been a rule in Colorado for a long time. Defendants have not received the benefit because based on a time of trial rule. So just in terms of consistency, which I think does create both justice and the appearance of justice, adhering to the rule that we have that has been applied, including by this court, I do think is the better rule in that regard.
So your opposing counsel pointed out the example of Wend and how in that case we essentially applied a time of appeal rule by applying Kreider and Dominguez Gomez in that case. Do you have a response to that?
Yeah, 2 responses. The first would be, I guess I disagree with that reading. I think the law on liar that was dealt with Wend is very clear. And I think, so it wasn't a new law. It wasn't substantive new change in law. But even if it was, I don't think there's any dispute that if anyone was to look hard enough, you could find cases on both sides where the court has applied this court has applied the time of trial rule and where the court has applied the time of appeal rule. But I will say most recently and repeatedly, this court has applied the time of trial rule. And as we pointed out in the brief, in the very first case in Colorado dealing with obviousness, which is Barker in 1975, it cited Sykes as being the standard for plain error, which says that plain error obviousness looks at the time of trial.
And in those cases, had the law in fact changed at the time of appeal? Or were we simply stating the rule because those were the facts presented?
Well,
In other words, the plainness, there was no question about plainness at time of appeal. It was only about plainness at time of trial.
In all those cases, this court specifically refused to grant the defendant relief because the error would not have been obvious to the trial judge. And necessarily in saying that the focus is on the trial judge, I think that this court was adhering to a time of trial rule. To get just quickly into the weeds of the Henderson, defendant argues that there's 6 reasons why Henderson applied the time of appeal rule. If you look at those 6 reasons as it applies to Colorado, either those considerations cut the other way, they're not applicable, or they carry little weight, where they carry great weight in the federal system. So the first one they identify is that that the U.S. Supreme Court in Henderson said it needed to do a time of appeal rule because of Johnson. This court, again, our precedent, I don't think there's any dispute, even though there might be some outliers, has generally adhered to a time of trial rule. Not only do we have Barker, but again, we have Penn, Scott, Romero, and Smith, and Sandoval. So that first one, I think, strongly cuts against a time of appeal rule. The second consideration was they were concerned about the conflict in the circuits. There is no conflict here. The Court of Appeals is bound by what this court said in Scott, and I think it has been applying Scott since. So the second consideration, that was one of the animating concerns of Henderson, doesn't apply at all here. The third consideration is the alleged temporal ping pong it takes for a appellate court to analyze whether an error was plain at the time or what the law is then versus what the law is now. Courts can do it. This court did it in all those cases I've mentioned, so I don't think it is really that difficult of a temporal ping pong. But more importantly, our courts also have this court's guidance in Scott, which stops that difficulty, where it says an error is plain if one of these 3 things happen. So again, that consideration is also not present in Colorado. The fourth claim is that the U.S. Supreme Court reached that result because it was consistent with the Schooner-Peggy principle. To my knowledge, Colorado has never adopted the Schooner-Peggy principle. I think the one case where this court actually talked about it, very old, it actually rejected the application of Schooner-Peggy. Also, if I'm remembering that case correctly, it's dealing with retroactivity. So I think just as a matter of general law, that case has a lot less force than it used to, and that we no longer presume retroactivity. The remaining considerations are that the court was concerned that there was no exception for a defendant who appealed and the new rule of law came out for them to actually file a challenge. As my colleague pointed out, that exception's not a concern in Colorado because we have 35C1. And then the sixth consideration was simply that they thought it led to more results. But I think, as I've already tried to point out, time of appeal rule also leads to incorrect results. If whether or not you get relief is based on the time that an appellate court reaches your appellate claim, that I see no purpose behind that rule versus the time of trial rule, which again, you don't get relief if it wouldn't have been obvious to the judge who actually decided your case or your attorney who didn't notice the error. And also with the more general purpose of, we have this whole rule because again, we want people to object. We want trials right in the first place. I see two very rational, justifications for a time of trial rule, but not for time of appeal rule. So I would respectfully ask this court to keep its prior decisions and not adopt the Henderson case. And just to briefly return, if this court were to find that stare decisis does apply, the defense would have to meet the additional barriers of saying that there's been a significant change in the law, which, as we pointed out in the brief, all those cases we cited are post-Henderson, so they can't make that condition. As to whether or not the error in this case rises to the level of reversible plain error, we think they lose under our test or their test, regardless of whether it's the time of trial or time of appeal. If it's under the time of trial rule, under, I think, 3 different theories, the error would not have been obvious to the trial court. One, we have case law saying that police officers can generally provide kind of testimony that's common in their experience. The very limited testimony in this case, just regarding that a airsoft gun has, a red or yellow mark and a small nozzle, that I think fits within a police officer's experience. We also have, at the time prior to Venalonzo, this court's cases in Gallegos and Farley, which said that although a witness may have specialized experience, if the testimony is just based on sensory impressions, it's not expert testimony. I think this certainly would fall into that. And then third, we also have all those Court of Appeals cases pre-Venalonzo saying, like Lane, Froehler, and Rincon, that if the testimony is the result of the processes of reasoning familiar to everyday life, such as observation, it's not expert testimony. And certainly the limited testimony we have here, I think, would have fit within that.
Go ahead, sorry.
Pounce. The Court of Appeals held that it was error under Venalonzo, correct?
It did.
And you did not cross-petition on that, right? So aren't we sort of stuck at least with that much? I mean, I'm wondering if you could point to why it doesn't require reversal here, but I don't know that we're in a position to revisit whether it's error under Venalonzo at this juncture.
Well, so all those arguments were that it was an error at the time of trial. So I'm not saying we did not cross-petition, and nor are we challenging the Court of Appeals finding that it was error, but the Court of Appeals found that it was not obvious error. I think both at the time of trial and at the time of appeal. So it wasn't obvious at the time of trial, nor do I think it was obvious prior to this case, because as the Court of Appeals found, no decision from any court had found that this type of testimony would have been improperly admitted as lay testimony.
Were you done? Can I, 2 specific ones were, the police officer was asked, do you feel like he was being truthful about his involvement? No. So directly commenting on a witness's credibility. And then the comment during closing argument where he said, ladies and gentlemen, there's only one person in this room that could tell you where all those items are now, and he won't. I mean, clearly commenting on his right to remain silent. Why are those not sufficient to warrant a reversal?
Under cumulative error?
Yes. I mean, you agree those are plain, right? Both of those errors are plain at the time of trial?
The closing argument, yes. I think it's arguable that the detective's testimony, given defense counsel's cross-examination, may or may not have been. During cross-examination, defense counsel, before that statement came in, asked or established through the officer that he had investigative techniques and skills to get defendants to say what he wanted.
So that opened the door to a credibility comment?
Or it could, but I'm saying it's possible. But, and again, whether or not this is before the court, given the cert question.
I understand, but we still have to
Of
determine
course.
the weight.
Yes. I'm saying it could have made it admissible under Davis, and that then it is an explanation as to investigative technique. So I think absent, so it's kind of opening the door, but also it gives it more context than being just a credibility discussion. But to the extent that this court were to find both were plain, they were fleeting, especially the one in closing argument. And this court knows the high burden for a plain error closing argument claim. It was just one statement that probably did cross the line, but also was responsive to the defendant's theory.
You'll go so far as probably? Huh? Only go so far as probably crossed the line?
I will go that
Word
far.
probably out, come on, you can do it. This was improper, right?
I will say that I will not challenge that I will not challenge the Court of Appeals finding that one was error.
All right.
Mr. Lee, before you completely shift gears and go into the cumulative error piece, can you stay with the Venalonzo issue and just tell me whether you concede that whether the gun was fake or real matters? In your answer brief, you said it doesn't matter. And I think that, as Ms. Rose suggested, it does for first-degree burglary, right? Okay.
It does, and that was, it does matter legally. It doesn't matter in the context of this trial because the issue was not disputed at all. The defense's argument never centered on whether or not that was a gun. It was just whether or not.
But a defense theory of misidentification is not a concession of other elements of certain offenses that he's charged with. I mean, the prosecution is still held to its burden. So just because it's not contested doesn't mean the prosecution doesn't still bear the burden of proving it beyond a reasonable doubt.
Of course. So I guess my first response would be, although not conceded, the evidence on that point was overwhelming, as the Court of Appeals found. The jury was able to watch the video for themselves. This court has the exhibits. If you look at the picture, it looks, I don't think there would have been any basis for the jury not to find it was a gun. Returning to the issue of whether or not that error would have been obvious, in this case, I do think it's interesting in that the defense's opening statement focused on the theory that the victim in this case was so scared, he was bothering police, and they kind of rushed to judgment and had found the wrong person. And part of that theory was, I think, buttressed by the idea that it was, in fact, a real gun. That's why he was so scared. They were going to come back. And if this court also looks at the defense's cross-examination of the detective, they established that if it was a real gun used in the video, there would have been real guns have gunshot residue. And they then go on to point out that throughout the searches of the defendant, they never found gunshot residue. So in terms of the fact that I think this evidence was used by the defense, it makes this error less obvious because it was used strategically in this case. And because, again, I think it was used strategically, that also goes to the issue of whether or not there would have been a reasonable probability that the jury would have found it was not a gun after this evidence, given that I think both sides' position was essentially that there was a gun, or at least not disputed, and given the other evidence, particularly the exhibits, and seeing the fact that it was a gun, the error was harmless and certainly not plain.
Are you going to turn to cumulative error?
Yes.
So
So
we've already talked about it a little bit in terms of the facts. Let me just ask you about the analytical framework. Obviously, Judge Berger was trying to establish something that would be maybe more useful to trial courts, provide a little bit more guidance about what sort of elements courts should be looking for in examining, or maybe other courts of appeals, I should say. Why shouldn't we do that as well? Why shouldn't we embrace something that provides more guidance?
So I guess my concerns with the test are principally that the test is already done. So when a reviewing court engages in whatever respective error review that applies, it's already looking at the error and any related errors. So in finding the error harmless, it's already done essentially what that test, or what the Caraway test and the Howard-Walker test is trying to do. So as a practical or as a principled and fundamental matter, just it's not necessary. The concerns from it are, and we pointed out two Court of Appeals cases, Stewart and Clark, is anytime you're kind of re-engaging in the same test over and over again, you kind of run the risk of the potential for human error. So the idea that, are you sure it's harmless? Are you really, really sure it's harmless? Are you really, really, really sure it's harmless? Not necessary, and to the extent it does change cases, it probably doesn't for the right reasons. And I guess as a practical matter, the idea that this is going to create a new test that we're going to have to deal with in briefs, I guess it's just, you're already doing what matters when you're arguing harmlessness, so the idea that you then would have to restack it and put it through all these different phases.
But I guess what troubles me is that it just sort of feels like we're left with a smell test otherwise, you know, it's just sort of, it's really nebulous. So surely we can do better than just, was the person deprived of a fair trial? Ultimately, that's the test that exists now under Oaks, right?
Well, and I think that's what it is. So as far as the Caraway test goes, I believe that that is already encompassed within regular harmless error review. And Connecticut and Georgia have pretty much rejected a similar test based on the idea that it makes no sense that way. What this court has said in Oaks and Kogan is, I think, created what is essentially a smell test, which is in very exceptional, very rare cases, there may be instances where there are many errors, which although each did not necessarily would result in reversal, that the court is so convinced that it creates an independent due process claim and that it precluded the defendant from having received a fair trial, that it is a tool for an appellate court to reverse.
Well, why isn't that this case? I mean, we have potentially 12 errors, and I understand it's not a numbers thing, I get that, but you have to admit, there are quite a few here, right?
There are a number of errors, but I think if you look, and I guess that's why I went through such great detail of the three, and I think it's only 3 cases where this court has actually found reversible cumulative error, as just how serious those errors need to be to have actually violated due process. And I'm kind of running out of time, but so I'll try to do this quickly. If you look at those cases, Kogan, Reynolds, and Oaks, I think there's a couple of common threads. In those cases, you have errors that went directly to the defendant's defense in a substantial way, and apparently in those cases, there was not overwhelming evidence. And I'd say in this case, none of those 3 strands are present. Most of the errors did not actually go to the disputed issue at trial, which was identity. To the extent some of them did kind of touch on the issue of identity, such as the girlfriend's testimony, it was cumulative to other testimony from those same witnesses. Because again, she also identified, there's also evidence that she identified the defendant. So her reaction, again, I think was cumulative and attenuated from that evidence. Even if, apart from it being cumulative, again, it's not the kind of prejudicial errors that this court found in the other cases. I mean, if this court closely reads, I mean, Oaks in particular, I mean, the errors in those cases were substantial and numerous. In those cases, there were several errors, all of which almost rose to the level of reversal, but certainly all of them showed that defendant was absolutely denied the right to fair trial. And I think in this case, it certainly wasn't. Especially given the overwhelming evidence in this case on the disputed issue, identity, which again was corroborated both with the picture we admitted, which matched the surveillance photo from Facebook. Can I finish?
Please.
The testimony from the girlfriend's uncle.
That is your thought, not the entire argument.
Yeah, just why it's overwhelming. So you have the matching of the Facebook photo to the photo of the surveillance. You have the girlfriend's uncle's testimony, the girlfriend's testimony, the defendant's statement in the interview, and you have that we matched his shoe to the footprint outside of the house. I'd ask you to affirm. Thank you.
Thank you.
Just to drill down a little bit on the cumulative error issue, Justice Hood, you asked whether this is really just a smell test. And I think, so the Court of Appeals below really did 2 things. They imported this Caraway 2-step protocol that opposing counsel and I agree is really inapposite in this jurisdiction. But they also used a number of factors from the federal circuits that I think are factors that appellate courts intuitively use anyway in evaluating whether an error is, multiple errors together are prejudicial. And I think that this court can look to those errors to guide the decision about whether any group of cumulative errors really rises to that level. So these, oh, go ahead.
I'm a little surprised that you representing the defense community, in a sense, on this issue, wouldn't want us to embrace something that mandates a more rigorous analysis of cumulative error as opposed to something that's more nebulous. And help me understand why you think it's bad for defendants to have this more rigorous test. in a
And to
sense.
piggyback on that, is it the specific factors in Caraway, or?
Yeah.
Okay.
Yeah, no, that's good. Thank you.
The factors I don't quibble with. The Baker or Sepulveda factors, I think that they're intuitive. The two-step process, I think, is difficult and unwieldy, and I don't think it's going to come to more just results. But I think that really the reason for that was this difference in the way that Colorado looks at plain error versus the federal system looks at harmlessness and plain error. And that's been undermined a little bit by this court's recent decision in James. Now, we know that when the state, when there's a preserved error on appeal that's not constitutional, the state still bears the burden. That wasn't clear at the time of the opening brief when I was really considering this test. But I still don't think it's necessary to have this way of looking at preserved versus unpreserved errors differently. Like at the point we're at cumulative error, this is kind of the floor. We just want to make sure this is a fair trial, and whether or not there was an objection really isn't the most important question. We're just looking at all the problems that happened here, 8 problems that happened that affected jury instructions, that were prosecutorial misconduct.
Won't you take Justice Moore's 12 errors?
I would love to take Justice Moore's 12 errors. and I would
I've
encourage
offered
you-
it like 3 times now.
Yes, 12 is even a better number. And I would emphasize, I went back and reread the transcripts. There was only 7.5 hours of trial from the moment that the prosecutor started opening statements to going into deliberation. So this was less than a full day. Whether it's 12 errors, whether it's 8 errors, that is a lot of errors, and it really undermines our faith that this man got a fair trial. And he respectfully asks that you reverse his convictions.
Thank you very much. We appreciate the arguments of both counsel. The case will stand submitted, and the court will be in recess. And I think we're going to have lunch with some of you folks, so we'll meet up with you shortly.